this seems like big news to me. So first, let me just do a gut check with both of you. I'll start with you, Harry, and go to Mary. Is it big news?
Yeah, it's big news. And, it's preceded by a few months of negotiation with Pence's team where he was jockeying perhaps for a voluntary interview, not doing it under oath. And Jack Smith, this sort of thing happened with Mueller, the January 6th committee. Jack Smith pulls the trigger. No, I'll see you at the grand jury. Enough sort of pussyfooting around on this. Pence has really critical information. He's probably framed the subpoena to maximize his legal chances, and that means stuff that you can't get from anyone else. That's first and foremost the one-on-one conversations on the phone and one in the wing of the Oval Office where Trump does a merciless and profane pressure campaign to get him to break the law.
Mary, what do you think?
Well, just going to that last point that Harry made, it's my understanding that merciless pressure campaign, that last call at around 11:30 on January 6th, is one that the vice president took alone without an aide there. And so that means there is no one else who can supply to Jack Smith evidence of what the president said and what Vice President Pence said back to the president at the time. Now, we have seen some clips from the President Trump's side of that call, but they were not complete. And so that is, I think, some critical testimony. And ultimately, if this is challenged on executive privilege grounds, which we can talk about, of course, in more detail, it will come down to, could this be obtained anywhere else? And I think there are some things that only the former vice president can provide.
Let's follow up on that, because that becomes the next question, right? So Vice President Pence, his stated, what he said about a subpoena from the January 6th committee was he would not cooperate, that he doesn't owe them his testimony, and he just said flatly no. Now, that wasn't litigated. It was just instead withdrawn before the committee closed up shop. So that just didn't go anywhere. This is a different thing. You get subpoenaed. You have to comply with that subpoena unless you have some case for why you don't. What would be the avenue, Mary, I'll start with you, by which theoretically the ex-vice president could challenge the subpoena?
Well, I suspect that either the vice president on his own or at the wishes of the former president will assert executive privilege. And, there's a number of different things to then consider. So first is whether a former president can even exert executive privilege. Now, the Supreme Court has never definitively resolved that, but they've come pretty close. And most recently, about a year ago, almost exactly, in the case of Trump v. Thompson, this was a case where the House Select Committee, of course, had subpoenaed presidential records from the archivist. Former President Trump asserted executive privilege. Current President Biden said, I'm not going to assert it. And this case went through the courts, and the lower courts held that that President Trump's assertion of executive privilege would not be maintained in the face of that. But Justice Kavanaugh the Supreme Court declined to intervene there. They did not take this case up, but Justice Kavanaugh left open the door that even a former president could assert executive privilege. Now, he said it might be a diminished right to executive privilege because executive privilege is about protecting the communications between the president and his highest aides so that they can speak to him with candor without worrying about those communications becoming public. And what Justice Kavanaugh said, and what has been said in other cases, is that that need for candor can extend even beyond a presidency. However, it might be reduced. And even when there is a sitting president, such as the case of President Nixon back during the Watergate scandal, even when there's a sitting president who asserts executive privilege in a criminal investigation, that can yield to a demonstrated specific need. Right. And that's what we're talking about with, even if we apply that standard, I think that Jack Smith probably has the better of the argument here, at least for some aspects of the former vice president's testimony.
There's also the complicating factor, and maybe it isn't, but I'm not making a legal point here so much as just a sort of intuitive common sense one. But it just does seem a little hard to write a 7-figure contract book in which you disclose details about the supposedly privileged communication. You write an op-ed in the Wall Street Journal called My Last Days with Donald Trump, and then tell the government that the substance of the things that you wrote a multi-million-dollar book about are privileged. Or does that not matter, Harry?
Yeah, it probably does. They call it waiver, but it's almost beside the point. Everything Mary says about the law is spot on, but let me just cut to the chase. He's going to lose this if he brings the claim. Nixon is just completely on point. Whatever rights a vice president have, they can't be greater than a president, and if there's a demonstrated need, and that's why we were both suggesting he has tailored his request probably carefully to get at what he can't otherwise get, he is going to lose. And there's a strategic question for him. He wants to announce for president. If he makes this challenge now, it will hover over him maybe in 8 months or whatever when it's played out and he loses. It will have been the thing that impaired his announcement all this time. There's a possibility, even though I know the reports are this will spark a executive privilege claim, there's a possibility that he will now say, now that he's looked like he's forced and there's the gun of a subpoena at his head, that he may comply now. And for political reasons, and Pence thinks about those things, it's probably a smarter move.
That timing question is an interesting one. I hadn't considered that in terms of where you want this to end up on the calendar, considering the other things he is considering. I guess I also wonder, Mary, and I don't know if there's any way to know this, so you can tell me, look, we just don't know, but what the timing here means about whatever decision-making is working its way through that office, right? Like when you subpoena the ex-vice president's a big deal, obviously. I'm not sure it's ever happened before. So when you do that, what's it mean, as best we can tell from the outside, Mary, about where this might be in the timeline that they're dealing with?
Yeah, and I always hate to speculate on the timeline of these things, but there's no question that they would have tried other means to get the information they are now seeking for a couple of reasons. One, because they know this is going to be a big deal. It's going to make the press. Here we are talking about it. It's going to, potentially engender litigation. And I would just note, even if the vice president wants to cooperate, I wouldn't put it past former President Trump filing his own litigation because he's done that before. So but putting that aside on the timing, so the Department of Justice through the special counsel will want to have established a record so that they can say to the court, we tried everything else and we have a demonstrated specific need. That doesn't mean it's the last thing they're going to do, but it does say to me they've tried to get at this information through other means. They're ready to talk to the vice president, and they still may have many other steps to go and they may learn things from Vice President Pence if they do end up talking to him that will then lead to additional investigative steps. But they're fairly far along in the process, I would say, or they wouldn't be taking this step. Well,
and there's also the fact that strikes me, Harry, the same question to you, but also the fact that there's only a small universe of other possible targets of the investigation his testimony could pertain to, right? I mean, he's there in the room at one point, I think, with John Eastman. And there's reason to believe that John Eastman might have criminal exposure. But really, it's about he's the guy who can testify to what Trump said and to his state of mind and to the fact that he was told by his lawyers it's not illegal. So it does also seem like Trump is squarely in the focus of anything you want to get out of Vice President Mike Pence.
100%. Other people can give the Eastman stuff. He can uniquely give stuff about Trump. So that really has to be the case. And in terms of Mary's surmise, I share it. It's that would be big news if true, right? Because we've been assuming they're really far along on Mar-a-Lago, not so much on January 6th. But I got to agree, every prosecutorial instinct in me says, whatever you do, you don't do this till you're fairly well along. You don't want to do it twice, that's for sure. And it does suggest, even though it contradicts the best evidence we've had to date, that Smith is far along, not just in Mar-a-Lago, but January 6th as well.
Yeah, it's an interesting point. I guess my final point here would be that whatever precedent is, particularly vis-a-vis privilege and Nixon, one of the things we've learned is that that and $3 gets you on the subway. What matters is if you can count to 5 at the court. And my strong suspicion is, for all the projects that the conservatives on that court have, bailing out Donald Trump isn't particularly one that I think you can count to 5 on. We'll see. But I don't think he has the votes there. Mary McCord and Harry Litman, thank you very much.
Yeah.